Good morning, everybody. I'd like to call the meeting of the House Health Committee to order, and I'd like, Devin, would you please take the roll?
Chair Frankel,
Here.
Representative Benham, Borowski, Boyd,
Designation.
Hambidge,
Designation.
Howard, Khan,
Designation.
Kozarowski,
Designation.
Krajewski,
Designation.
Mays,
Designation.
Prilatin,
Designation.
Sanchez,
Here.
Schusterman, Venkat, Chair Rapp,
Here.
Representative Bonner, Borowitz,
Designation.
Brown, Day, Krupa, Roy,
Here.
Rossi, Stair,
Designation.
Twardzik,
I'm here.
Walsh, Zimmerman. We have a quorum.
Thanks, Devin. First up, the chair calls up House Bill 425, printer's number 400, sponsored by Representative Marcel. Mike, can you please provide a summary of the bill?
Thank you, Mr. Chairman. House Bill 425, introduced by Representatives Marcel and Venkat, will establish the J-1 Visa Waiver Primary Care Physician Grant Program under the Department of Health. The program will be funded by a $10 million appropriation from the general fund to provide grants to eligible employers to employ physicians. Physician is defined as a medical doctor or doctor of osteopathy who primarily provides medical services in any one or more of the following practice areas: family medicine, osteopathic general practice, general pediatrics, geriatric medicine, emergency medicine, psychiatry, obstetrics, and general internal medicine. The employer may receive $100,000 a year for a period of 3 years. The department may award grants in increments of $10,000, not to exceed $100,000 each year. The department is required to publish annual reports by December 31st. House Bill 425 is supported by St. Luke's University Health Network, the Pennsylvania Rural Health Association, the Pennsylvania Medical Society, and the Hospital and Health System Association of Pennsylvania. Thank you, Mr. Chairman.
Thank you, Mike. The question is, will the House report House Bill 425? Representative Venkat is offering Amendment A00805. Patrick, would you please explain the amendment?
This is an agreed-to amendment which establishes program funding through the normal annual budget appropriation process and not through a one-time appropriation. The amendment also removes two specific federal designations that were used as requirements for program applicants. This was a technical request from the Department of Health. Finally, the amendment also extends the time window for which grant funds may be dispersed by 2 years.
Thank you. Are there any comments on the amendment? Seeing none. Are there any negative votes on Amendment 8?
Yes.
There are. Okay, then would Devin, will you please call the roll?
Chair Frankel,
Yes.
Representative Benham, Borowski, Boyd, Hanbidge,
Designation, yes.
Howard, Khan,
Designation, yes.
Kozarowski,
Designation, yes.
Krajewski, Mays,
Designation, yes.
Prilatin,
Designation, yes.
Sanchez,
Yes.
Schusterman, Venkat,
Yes.
Chair Rapp,
Yes.
Representative Bonner, Borowitz, Representative Brown, Day,
No.
Krupa,
No.
Roy,
No.
Rossi, Stair,
Designation. Yes.
Twardzik,
Yes.
Walsh, Zimmerman, 19-7 passes.
The amendment passes, and the question recurs. Will the committee report the bill as amended? On that question, the chair recognizes Representative Marcel, who is here in attendance. Representative Marcel.
Thank you very much, Mr. Chairman, and thank you very much to the chairs for considering this bill today and the committee for listening to really the reason behind this bill, which is a constituent of mine. I also wanted to thank Representative Venkat for working on this bill together, as well as Dr. Cavalli, who was my constituent who came to me when I first was sworn in to talk about this issue and was really the reason for this bill. So I have a statement to read that is really his story, just to help explain a little bit about why I'm working on this bill. In late April 1994, Dr. Cavalli was entering the last 2 months of internal medicine residency in New York. He faced a choice between continuing his medical training in New York on a J-1 temporary visa and subsequently returning to his native country of India, or applying for a waiver of the requirement by serving in a health professional shortage area. In passing, his tax preparer had mentioned about 2 weeks earlier about an agency in Houston that was accepting applications and resumes from physicians in his position. Within a week, he was connected to the director of a tiny parish hospital in southern Louisiana. By early June, he and his wife were visiting the hospital for an interview. By late June, he had an employment contract signed. 4 months later, he and his wife were able to obtain immigration papers via the U.S. consulate in Toronto, Canada. They moved to Lutcher, Louisiana on Thanksgiving Eve of 1994. During his stint at St. James Parish Hospital, Dr. Cavalli treated the poorest to the town leaders and built great relationships with local physicians and nurses. He returned to New York for further training in diabetes and endocrinology from 1997 to 99, after which he moved to Bucks County, PA. He has practiced here since then, establishing a robust independent practice that has become a crucial resource for the community, including Northeast Philadelphia and Eastern Montgomery County. Currently, as president-elect of the Pennsylvania Medical Society, he is keen on helping communities in Pennsylvania that have similar medical care needs to St. James Parish, Louisiana, and new graduates of the many primary care residency programs in PA who were on J-1 temporary visas. Simultaneously, his goal is to help independent medical practices establish primary care clinics in medically underserved areas and health professional shortage areas in PA. The proposed bill will go a long way in achieving all of this, the win-win outcome. Additionally, it will help to retain U.S.-trained international medical graduates in the United States, specifically in Pennsylvania. This bill addresses a critical need and offers a practical solution. Facilities across the Commonwealth are facing a shortage of physicians, and this shortage is exacerbated in rural and underserved areas. Facilities are doing all they can to attract and retain highly trained physicians, but they often face insurmountable obstacles when competing with big health systems. This bill is tailored to address some of those obstacles. While it will not solve the problem completely, it will help those facilities who choose to apply for one of these grants to hire physicians to work in these areas. And hopefully before their service is done, these physicians will choose to stay in these areas and continue to care for the people of this Commonwealth. So thank you so much for listening to Dr. Cavalli's story, and appreciate any questions or comments you may have. Thank you.
Thank you, Representative Marcel. Recognize Representative Venkat.
Thank you, Chair Frankel, and thank you to Representative Marcel. It's been a pleasure to partner with you on this important legislation. As the son of 2 international medical graduates who did their residency here and had a similar journey to Dr. Cavalli to put down roots in the United States and provide care to patients, and the family member of a number of international medical graduates, I think it's important for us as a legislature to recognize how critical the international medical graduate workforce is to the future of healthcare in Pennsylvania. These are individuals who are here legally vetted by the United States government, are training here disproportionately in Pennsylvania, and we have the ability to retain them in areas that are desperate for physicians in high-need areas. And this legislation provides a vehicle for the state government to support that effort and to build our healthcare workforce in Pennsylvania. So again, thank you to Representative Marcel. Thank you to partners on both sides of the aisle to bring this legislation forward, and I would certainly urge an affirmative vote.
Thank you. Are there, before I recognize Chair Rapp, are there any other comments? Chair Rapp? Sorry. Yes, Representative Roy.
Thank you, Mr. Chairman. This is a very well-intended bill, but I do have some concerns. I realize the $10 million is not in the bill anymore to fund this thing, but the general fund budget is already out of whack by $5 billion of deficit spending. So I don't know where the $10 million would come from to do this. And I also have concerns that if a hospital or a doctor's office, if they had to hire one more doctor, if they hire an American citizen, they'd have to pay the full salary. If you hire a non-citizen under this program, the government pays $100,000 of the salary, up to $100,000, and that just doesn't seem right. But I'm concerned about the fiscal cost. I don't even know how we're going to balance the budget with a $5 billion deficit, and we shouldn't be adding another $10 million in costs. And I just don't think it's fair that non-citizen doctors basically get a subsidy to get hired. If I worked at a hospital, I might hire the non-citizen just to have the government pay part of the hiring cost rather than having to pay the whole salary. Thank you.
Thank you. Chair Rapp.
Thank you, Mr. Chairman. I think we all know that healthcare, and especially rural healthcare, is in a crisis. I don't think anyone can question that. Rural counties in this Commonwealth often lack an adequate number of healthcare practitioners that are needed for their residents. According to a February 23 study, there are approximately 2.6 million Pennsylvanians who are medically underserved, and this problem is magnified in rural areas, as residents must often travel further to obtain health care services compared to their urban and suburban counterparts. The J-1 visa program has been in existence in some forms since 1961 through the federal government. In the past, the hospital in my district employed physicians that were in the J-1 visa program. Rural healthcare providers are often at a disadvantage in competing with providers in urban areas as they cannot compete with salaries and other terms of employment. This optional grant program will help these employers hire and perhaps retain physicians to live and work in their communities. I will be supporting moving this bill, Mr. Chairman, out of committee, and thank you. Thank you, representatives, for sponsoring the bill.
Thank you, Chair Rapp. Let me join Chair Rapp in support of this bill. We have on this committee been working diligently to address the real crisis of access to care in our rural communities, and doing that on a bipartisan basis. And this bill helps address that. We know that physicians on J-1 visas often begin practicing in these communities, and then they stay for life. So I would like to ask members for a yes vote on this. And with that, those in favor of reporting House Bill 425 as amended will vote aye. Those opposed will vote no. Devin, will you please take the roll?
Chair Frankel.
Yes.
Representative Benham.
Yes.
Borowski. Boyd. Hanbidge.
Designation yes.
Howard. Khan. Kozarowski.
Yes.
Krajewski. Mays.
Designation yes.
Furlaten.
Designation yes.
Sanchez.
Yes.
Schusterman. Venkat.
Yes.
Chair Rapp.
Yes.
Representative Bonner. Horowitz.
Oh.
Brown. Day.
No.
Krupa. Roy.
No.
Rossi. Stair.
Designation yes.
Twardzik.
Yes.
Walsh. Zimmerman. 19-7. Passes.
Thank you, members. House Bill 425 will be reported as amended. I'd like to call up House Bill 583. Chair calls this up, House Bill 583, printers number 593, sponsored by Representative Curry. Erica, can you please provide a summary of the bill?
House Bill 583 removes the coverage limitation preventing Pennsylvanians from accessing dental care, including treatment for gum disease, additional dentures, crowns, or root canals, except in those cases where the patient already has a serious medical condition. The benefit change would not take place unless funds are provided for and after approval from CMS.
Thank you. Representative Curry is unable to be with us today for commitment in her district. And with that, is there any discussion on the bill? Representative Roy?
Thank you, Mr. Chairman. Again, the budget proposal has about a $5 billion deficit, money taken out of reserves. It's not sustainable to do that. When you add coverage for anything, covered by medical assistance, you're adding, obviously, to the total amount of spending. You're adding to that deficit. So we can't really afford to do it. Medical assistance line items accounts for about a fourth of the Pennsylvania general fund budget. So it's not that we don't spend money on medical assistance. It's just there has to be a limit at some point of how much the taxpayers can afford. And when you have a $5 billion deficit in the budget proposal, I just don't think it's responsible to add more to the cost. Thank you.
Thank you. Other members? Representative Day.
Thank you, Chairman. Usually I do this before the committee, but is there a fiscal note to the impact of this bill?
There is not, and it's difficult to calculate this. This change was made back in 2011 to limit access to these services unless you have a serious illness such as cancer, diabetes. And at the time, the estimate was that it would save $20 million. However, since then, we have had Medicaid expansion, and we've never been able to actually figure out how much was saved, if any. So it's hard to know what the impact would be because the population has changed so much. And as far as fiscal note, should the bill pass itself, the bill would only take effect should the money be appropriated by the General Assembly. So what the bill does is it removes the limitation should the General Assembly choose to appropriate the funds.
Thank you. And just a brief follow-up. So I don't know that I understood the end of that. So a brief follow-up question is, I thought we would need a fiscal note at least on the floor, at least an estimate from somebody. But I think you just said we don't now, but we might after the budget. I didn't understand that part.
So generally, and in House Bill 425, we removed the appropriation. So we don't generally do appropriations in committee. Those decisions are made in terms of appropriations generally by the Appropriations Committee and in the budget process. So should the General Assembly decide to appropriate funds specifically for the medical assistance dental benefit, then this would take place. What this bill does is essentially says it's now possible because the current law prevents the expansion of the dental benefit in statute. So this would remove that limitation in statute, and then should the General Assembly have the will to go ahead and appropriate the funds, then they could expand the benefit.
Thank you for that explanation. Thank you, Mr. Chairman.
Chair Rapp.
Thank you, Mr. Chairman. I also have concerns about the bill, mainly how it will be funded and what the actual amount will be. For this bill last session, we received varying estimates as to the Commonwealth's funding obligation. However, I do support proper dental care for our citizens, as the lack of dentists who will see medical assistant patients in rural areas is a big concern. A few years ago, even for children, there is a hesitancy on the part of dentists to provide services for children. Not all, but many. A few years ago, I sponsored House Resolution 68, which directed the Legislative Budget and Finance Committee to conduct a study to review the availability of dental services in rural areas of this Commonwealth and to provide a report detailing the options for improving access to oral health care services. The report highlighted many deficiencies in rural access to care for dental services. Financial coverage of dental services is a huge issue in rural areas. For many of my constituents, they can travel an hour or more if they have Medicaid, even for their children, for services. While I do have concerns with the bill, I feel that it should move forward. I hope we receive more definitive information as to the fiscal costs for this bill, as I'm sure we will, as it moves through the legislative process. But at this time, I will be supporting this bill in committee, and thank you, Mr. Chair.
Thank you, Chair Rapp. In 2011, Pennsylvania changed the dental benefit package. Currently, in order to get treated for gum disease, receive a second pair of dentures, or get a crown or a root canal to save a tooth, you must have conditions like diabetes, cancer, or coronary artery disease. A patient can go to the dentist for a basic cleaning, but if they have gum disease, they can't get their disease treated. An amendment will be offered on the floor to give flexibility to the Department of Human Services to restore benefits piecemeal if a full restoration isn't possible. I'd like to ask for members to vote yes today to moving this bill out of committee. And with that, those in favor of reporting House Bill 583 will vote aye. Those opposed will vote no. Devin, will you please take the roll?
Chair Frankel.
Yes.
Representative Benham. Borowski. Boyd. Hanbidge.
Designation yes.
Howard. Khan.
Yes.
Kozarowski.
Yes.
Krajewski. Mays.
Designation yes.
Kriolatin.
Designation yes.
Sanchez.
Yes.
Schusterman. Venkat.
Yes.
Chair Rapp.
Yes.
Representative Bonner. Horowitz. Brown. Day. Krupa. Roy.
No.
Rossi. Stair.
Designation yes.
Twardzik.
Yes.
Walsh. Zimmerman. The A's are 22. The nays 4. Yeah, the bill passes out of committee.
Thank you, members. House Bill 583 will be reported as committed. I'd like to call up House Bill 1460, printers number 1696, sponsored by Representative Borowski. Erica, can you please provide a summary of the bill?
Bear with me, it's a little long. House Bill 1460 provides the Attorney General oversight of financial transactions related to healthcare that might be against the public interest and provides for ongoing monitoring if needed. A for-profit or private equity group that wants to purchase a healthcare facility or provider group or leverage any of the assets of the facility must file notice with the Office of the Attorney General by sharing required documents. Transaction thresholds are $5 million. Following the notice, the Attorney General's office has 90 days to review the documents and can require one 30-day extension. Any other extensions must be approved by the court. The office can, but is not required, to hold public hearings. If the Attorney General determines then the Attorney General determines if a transaction is against the public interest or the transaction moves forward. The definition of against the public interest includes reduction in competition or increase in costs that are not related to quality, unfair competition, reduction in quality of care, reduction in access to services, particularly in a rural, low-income, or disadvantaged community, or a sale-leaseback agreement. If a transaction is determined to be against the public interest, the Attorney General's office can work with the entities to create a voluntary agreement where the deal can go through with conditions for oversight. Alternatively, the office can file to block the deal in court. The Office of the Attorney General can contract with necessary experts, and the entities will pay the costs of any contracts. The Office of the Attorney General must work with the Department of Health in determining the impacts on the community and on healthcare services. In the case of a voluntary agreement, the Attorney General can oversee financial issues, and the Department of Health can review quality issues for up to 5 years of initial oversight. If the Attorney General determines that it is appropriate, monitoring can continue. Any of the materials related to the transaction that are provided to the Attorney General's office cannot be used in civil cases, be subpoenaed, or be subject to the right to know law.
Thank you, Erica. The question is, will the committee report House Bill 1460? Representative Bonner is offering Amendment A00836. Mike, would you please provide a summary of the amendment?
Thank you, Mr. Chairman. Amendment A00836, introduced by Representative Bonner, will do the following. It will remove practitioner organizations from the bill, increases the material amount threshold from $5 million to $10 million, decreases the waiting period for when a healthcare entity may enter into a binding cover transaction from 90 days to 60 days. For any additional extensions requested by the Attorney General beyond what is set forth in the bill, the Attorney General has 5 days in which to request the additional extensions from the court, and it will require the Attorney General to also notify the governing body of the municipality in which the healthcare entity is located when the Attorney General conducts a public hearing. It is our understanding that this is an agreed-to amendment. Thank you, Mr. Chairman.
It is also my understanding that this is an agreed-to amendment with the prime sponsor. Are there any negative votes on the amendment? Representative Bonner.
Thank you, Mr. Chairman. I would like to thank the prime sponsor of the bill, Representative Borowski, for her fine work and her willingness to discuss and reach agreement on suggested changes to the legislation. And also Executive Director Erica Frick. Representative Venkat also played a significant role in this amendment, and as did legal counsel for the Health Committee, Michael Siggett, and our two chair individuals. So I appreciate their willingness to work with me in attempting to make a good bill better. And as Attorney Siggett indicated, in my judgment, there are 3 primary suggested changes to this bill. The first change is that we are going to remove independent physicians from the coverage of this bill. Independent physicians are those, by definition, who practice on their own. They're not part of a larger health system. And they've hung their shingle up. It used to be 30 years ago, that's how most physicians practice medicine. But today, 75% of our physicians are employed by hospital systems. But we still have a remnant of our physician population practicing on their own. And this legislation would remove the regulation of the independent physicians from this legislation. Attempting to regulate for-profit hospitals and for-profit nursing homes and independent physicians in one bill is truly mixing apples and oranges. They have very different goals and objectives. Trying to regulate independent physicians in this bill would be comparable to trying to regulate professional football and professional baseball in a single bill as well. The two just don't mix well. And forcing independent physicians into this bill would create a lot of confusion and a lot of difficulties in its enforcement. So I think it's a step forward to remove independent physicians from this legislation. Secondly, this bill reduces the time frame that the Attorney General will have to review any proposed sale, purchase, or merger from potentially 120 days to 90 days. And when you're involved in a merger process, particularly of institutions of this size and importance, timing is everything. Timing is important to the parties to make certain that the transfer occurs as quickly as possible. It is important to the community that is very much concerned about whether health care will still remain within their community. And it's important to the employees of the institution that they have knowledge and stability that their positions are going to be maintained. So reducing the time frame for the Attorney General's approval is also very significant. Thirdly, the monetary threshold for triggering the review and approval of the Attorney General's office has been increased from $5 million to $10 million. We just want to make certain that, well, we are covering more significant transactions than potentially lower level purchases or mergers. These amendments then are critical to hopefully obtaining bipartisan support for the legislation, at least at today's committee meeting. We understand that there may be significant opposition to this bill as we move forward, and we welcome the input of the different stakeholders and the citizens. I know all members of this committee are open to your ideas and suggestions, but for today's purpose, we believe that these three amendments are very significant and will help build a strong consensus for the passage of this bill. I would therefore ask the members' support for this amendment, which concentrates on one specific segment of the healthcare system, and that is the for-profit hospitals and nursing homes. It quickens the decision-making process for the Attorney General's office, and it covers more significant financial transactions than originally proposed. Therefore, I'd ask your support for today's amendment. Thank you.
Representative Borowski.
Thank you, Chair Frankel and Chair Rapp. I would just like to thank Representative Bonner as well as Mike Siggett for their work on this amendment and your thoughtful review of the legislation. And I would ask my colleagues for an affirmative vote as this is an agreed-to amendment.
Thank you. Any additional comments? Seeing none. Are there any negative votes on Amendment A00836? Seeing none. Amendment 800836 is adopted. The question recurs, will the committee report the bill as amended? Is there discussion on the bill? Representative Bonner.
I didn't think I would be back to the microphone this quickly, but I want to comment on the merits of this particular legislation. The providing and payment for health care services in a hospital setting is no longer a private matter. Regardless of whether the hospital is deemed a for-profit institution or whether it is deemed a not-for-profit institution. But there are major differences between the operation and purpose of a not-for-profit hospital and a for-profit hospital that this bill attempts to address. Please recall that this bill is addressing for-profit hospitals. Not-for-profit hospitals are managed much differently than for-profit hospitals. They, by law, have a charitable purpose at all times, and they are governed by a board of directors who are chosen from members of their community. And they seek to serve the public interest of the patients within their community. The board of directors of a nonprofit hospital have a fiduciary duty to the members of their society that their decisions enhance the mission of providing health care within their communities. Their purpose then is solely directed to providing health care, an effective health care within their communities. Their boards of directors primarily come from the communities, so they're very much in touch with their constituents. The for-profit hospitals, however, they are governed much differently than not-for-profit hospitals. The for-profit hospitals have a dual conflict in that they are serving a board of directors who are elected by the shareholders, not by the community. And although they do have a primary purpose of serving healthcare needs in their communities, they also have an overriding purpose of serving the interests of their shareholders, which is very different than a not-for-profit hospital. Although I do have concerns about the salaries paid to executives at nonprofit hospitals, no funds of a not-for-profit hospital go into the hands of investors or shareholders, unlike for-profit hospitals. These are two very distinct institutions providing health care within our communities. The for-profit hospital then is governed much differently and behaves much differently than a not-for-profit hospital. Attempting then to serve two masters, we have found, is very difficult. And for-profit hospitals do attempt to serve two masters. They look to serve their shareholders and their investors. And their board is primarily comprised of members of that particular group. And they do look to serve the interests of the community to provide medical service, but oftentimes there is conflict in those two roles. And we have seen the devastating effects of the conflict when healthcare services are put behind the demands of the investors. We have encountered then too many occasions where for-profit hospitals have put the needs and demands of their investors and shareholders above the public interest of their community. And in particular, I've seen it in my own county, where Sharon Regional Hospital recently underwent a very serious problem and confrontation when that nonprofit hospital was ultimately sold to a for-profit hospital, Steward Healthcare, which owns 33 hospitals across the nation. And as a result of putting the interests of their shareholders and investors above the needs of the community, these hospitals have faced closure and unfortunately very forced sales that may not be in the public's best interest. This practice must stop, and House Bill 1460 will help bring greater oversight to the actions of the for-profit hospitals. House Bill then 1460 will authorize the Attorney General to review, to investigate, and if certain criteria are met, to deny the sale, the purchase, the lease of a for-profit hospital if it is found to be against the public interest and involves more than a $10 million transaction. It will also provide for any ongoing monitoring of the for-profit hospital who engages in such transactions, so that it won't just be a one-time review. It will allow for monitoring of that for-profit hospital engaging in this type activity. Monitoring which the for-profits have brought upon themselves. Not-for-profit hospitals already have oversight by the Attorney General's office. Just by their inherent nature of being a charitable institution, the Attorney General's office has the right to monitor their mergers and sales. So this is now bringing the for-profits under the umbrella also to be potentially reviewed and monitored if the transaction exceeds $5 million. The actions then of for-profit hospitals in Pennsylvania and across the country have brought these regulations upon themselves. Government is the major source of funding for all hospitals in the United States. 67% of all hospital costs are paid for by the government. The government then has a very vested interest in seeing that these hospitals and their primary goal is to serve the needs of the public and the constituents and the patients. This legislation then is essential to protect the rights of the taxpayers, to protect the rights of the patients, and to make certain that these hospitals, these for-profit hospitals, are acting in the best interests of the general public. And I'd ask your support for the bill.
Thank you, Representative Bonner. Representative Venkat.
Thank you, Chair Frankel. I certainly share the concerns that have come out of hospital closures across the state related to the tactics of private equity. I have colleagues who should be caring for patients at Crozier Health System who are not because of the closure. But I have grave concerns about this legislation. As originally proposed, I think it has been improved with the amendment. But I don't think it gets to the root issue of what we are facing, which is that we as a legislature and have totally abdicated our responsibility related to antitrust. We have not been willing to pass legislation that would allow scrutiny of healthcare transactions across the board, nonprofit, for-profit, private equity, involvement of insurance companies, and vertical and horizontal integration. And we also have not done the hard work of ensuring that reimbursement under state programs, specifically Medicaid, can pay the freight for what is needed to sustain healthcare services in high-need areas. And as a result, because we have abdicated those responsibilities, we are left with private equity and other entities, including insurance companies, coming in to say that consolidation can make a difference in terms of sustaining vital public resources. And let's be clear, in the acute care hospital space, private equity comes in when they identify an asset that they believe the breakup value is going to be worth more than sustaining the clinical setting in a responsible way that we hope for. So I have three concerns with the bill, even after amendment. The first is the provision that says that if the Attorney General states that there's only one entity that can keep a facility open, that all of this review will go away, I think will be used by private equity to say that we're the only ones here because they identify distressed assets. They're not going after healthy hospitals. The second is in the provisions as to how the Attorney General is judging the public interest. In two of these cases, it explicitly allows payers to state that it may increase their costs. And when insurance companies have been allowed in this state to have vertical integration in this state, it is abundantly clear that this is giving a de facto veto on virtually any healthcare transaction in this state that is involving hospitals, when we've already allowed insurance companies to have, certainly the case in Western Pennsylvania where I am, a duopoly. And the third instance is that this is now bringing in facilities, because of the definition of the Healthcare Facilities Act, that go well beyond acute care hospitals. It goes to ambulatory surgical facilities and a number of other facilities. I will vote yes to advance this legislation from committee in the hopes that we will be able to further amend this bill. I do think we need a comprehensive antitrust statute. If we're not going to do that, we should narrowly craft this bill to focus on private equity's role in acute care hospitals and not extend a de facto veto to payers. If the bill does not change, I want to go on record that on the floor I will be a no because of the reasons that I've articulated.
Representative Roy.
Thank you. Thank you, Mr. Chairman. I'm concerned that the bill does not cover nonprofits. The bill analysis states that the Office of Attorney General has broad powers to investigate charitable nonprofits based on case law. So case law is just something that some judge decided. It's not written down in an actual statute anyplace. There's a document that the Office of Attorney General uses, but the bill analysis says the document is voluntary, not compulsory. So I guess my concern is if a big hospital organization like Geisinger, UPMC, LECOM, nonprofits like that, there have been hospitals closed in Pennsylvania when those big nonprofits acquire hospitals. And I just think that it's not right. There's parts of hospitals, maternity areas of hospitals owned by these big nonprofits get closed. And I just think if we're going to make sure that if one, medical facility buys another one, I don't think it should matter whether it's a for-profit or not-for-profit. You can't leave all those people without access to maternity care or a hospital in general. So I'm opposed to the bill. Thank you.
Representative Boyd.
Thank you, Chairman, and thank you, Representative Borowski, for this bill. I found myself just now in an unusual position of agreeing with the two speakers ahead of me. That doesn't usually happen in the way that happens. But I have, I represent Delaware County, and I have had a front seat with a lot of the folks in this room for the devastation and the, just fury that we have had to experience to watch this particular historic healthcare system be decimated and destroyed by people and by organizations that were the for-profit that Representative Venkat was explaining, and Representative Bonner, that are ruined us and destroyed us and didn't care. They didn't care, and I do think that we can't wait to let the perfect be the enemy of the good in this situation. I agree that there is a lot we can help and fix in healthcare in Pennsylvania and in the United States. And we all know that those debates have been happening for decades, and there are big entities that fight us on these things. So I want to just thank the members of the room, especially my PASNAP friends who have been fighting for years to try and hold down the healthcare in Delaware County and have had it stripped from us. And I have to support this legislation because it will stop at least that specific horror that happened to us from happening again in Pennsylvania. But I encourage all of us to, I hear what Dr. Venkat is saying, Representative Venkat, and I agree that we need to make some of these changes, and with Representative Roy to say we need to go further. But in this case, I can't oppose this bill, right, to say let's let the perfect be the enemy of the good, because we see the political will not going in our direction sometimes. And so with the cuts proposed at Medicaid at the federal level, how can we say that we also need to just take a pause and maybe allow these kinds of detrimental actions to continue to happen in Pennsylvania? We can't fix it all at once, but I support this legislation because I had a front row seat to what Crozier did in my community, and we are without health care in Pennsylvania, or at least in Delaware County, in a way that makes us all very uncomfortable and nervous. And I want to thank all of the nurses and doctors who continue to fight and continue to help to provide health care in my community, even as we face such detriment. So thank you, Representative Borowski, and I ask you all to vote yes on this, not letting the perfect be the enemy of the good.
Thank you, Representative Boyd. Representative Khan.
Thank you. So this is actually one of the reasons why I decided to run to be a state rep. I saw what happened in Hahnemann Hospital, 2018. 800 nurses lost their job. Bunch of residents lost their residency. Most importantly, our patients lost their access to care. And I felt that we needed someone in the government to be doing something, preventing that from happening in the future. And it just happened in Crozier. It just happened, the same thing. Private equity, private company coming in, promising a lot, leaving nurses, leaving patients, leaving providers stranded. And now there's 400 nurses that are left without a job. Some of them are in this room, and I thank you for being here. And some of the physicians are in this room, and I thank you for being here. We have to do something to stop this from happening. Again, this is something that is a long time coming. I actually worked on a similar bill last session. Rep. Borowski's bill was better, and this is the bill that's getting moved, and I am proud to be a co-prime sponsor on this, along with the Delaware County representatives and Representative Takak. This is, and also Senator Kearney has this in the Senate. This is a common sense approach, It's not the be-all and end-all. There is clearly more to do, but we have to do something to protect our patients. We have to protect our nurses and our providers. We can't let private equity, we can't let private corporations continue to pillage our communities in the name of profit. So thank you, Chairman. Thank you for taking up this bill, and I encourage a yes vote on this bill. And most importantly, thank you, Representative Borowski, who's been leading this effort, who's been having those hard conversations, who've been dealing with the stakeholders to make this bill what it is. Thank you.
Thank you, Representative Khan. Representative Borowitz.
Thank you, Chairman. I'm going to take a different route here. Involving the government in this problem is not the solution. I think Ronald Reagan said it best when he warned us about government-controlled healthcare. When I ran for office, I was never so shocked when I got here to actually see the intermingling of government with our healthcare system and the warnings that Ronald Reagan gave us. I think it was like a 12-minute video. Everyone should watch it. Because if they can get into our healthcare, the government can. They can get into every aspect of our lives, he told us. And so this is just another bill. I'm not saying there's not an issue and a problem here, but this is just another bill that involves the heavy hand of government in our healthcare system. I have some real questions and issues with this. Did you say there's 5 years of oversight from the AG's office after the transaction? Is that correct? Did I hear you correct in that?
Not necessarily. There is an option. So, for example, one of the occurrences one of the financial strategies used by private equity in particular has been the sale of the property, whether that's the hospital or the nursing home, to a separate entity. So the large corporate structure will have what's called a real estate investment trust on one side that is separated financially from the actual healthcare facility, whether that's the nursing home or the hospital. And then, so they will sell off the actual property asset to a separate company and then require the healthcare facility to pay rent to that company. And one of the issues that we've seen in some of these transactions is that rent has been, quite frankly, exorbitant, and so it impoverishes the healthcare facility. They're also responsible for what is called, I want to say it's I have to look in the bill analysis, but they're responsible for all of the upkeep of the building and all of the liability. So you end up essentially removing most of the assets from a healthcare facility while the corporate investors are still making a profit. And so I think what the idea is within here, and in the case of Crozier, for example, the initial sale happened about 5 years before the sale leaseback, in my understanding. And so what the Attorney General's office could do is monitor to say, okay, yes, we believe that it makes sense for you to come and invest in this healthcare facility. It's a needed investment, but we want to make sure that you're not then simply taking the assets in a way that then harms the actual facility. And it allows for that ongoing monitoring in cases of, say, a sale-leaseback transaction, that maybe it makes sense to sell the underlying building, but maybe it doesn't make sense to allow extremely high rents that increase annually. And so it allows them to continue monitoring in a way that protects the healthcare facility.
Okay, so long story short, that their government's involved for 5 years. Thank you. Okay, next question. AOG, the Office of Attorney General, must give information to the Department of Health, the same Department of Health that during COVID mandated COVID patients back into nursing homes. So we're going to then give off that authority, okay, to also involve the Department of Health if needed, so that they can review any proposed transactions related to the Healthcare Facilities Act at the same time. These documents are also not subject to the right to know law. So none of this is now subject to the right to know law, so there's no transparency in all of this also involving the government and our healthcare systems. Is that correct? There's no right to know ability to have any of that information.
So I think the issue there is that these are considered important financial documents by corporations, and they want them protected. So correct, they are not
sure,
subject
just
to the right
like
to
when
know
they
law.
always say classified to protect us. Right, got it. Okay, thank you.
Before I turn to the prime sponsor and the chairs, are there any other members who have comments or questions? Representative Day.
Thank you, Mr. Chairman. Mr. Chairman, our colleague, Representative Bonner, stated it brilliantly that government funds, I think it was 67%, and we have a vested interest and we should participate in these transactions. However, I have a concern with giving this legislative vehicle to our body if we're going to focus on protecting jobs or protecting wages or determining need for services like through a certificate of need process. I think that's the wrong way to use this legislative vehicle, but I do think we need to participate in these transactions. So I'm very conflicted on this piece of legislation, but here in committee, I'm willing to vote yes, to move this to the floor, and hope that we continue to direct this in the right way and go towards governmental, maybe even not legislative, but governmental oversight, vest that authority in the right place, but not go too far where we're determining healthcare services, like, I'll say it again, certificate of need process, or, I appreciate, and we're all here to protect our residents, and I appreciate our colleagues' comments. And I don't dissuade him from continuing to fight for his people. And we have the same thing happening in the Lehigh Valley, and we have multiple service providers in the Lehigh Valley, and we'll be seeing more. We've seen a merger with another entity, and having government oversight or involvement, I think, is an important thing to do. So, Mr. Chairman, I'm hoping that this legislation starts to reflect that minimal oversight in the transaction, the intention of the new provider, and the services to the community. Thank you.
Thank you. Now for the prime sponsor, Representative Borowski.
Thank you, Chair Frankel and Chair Rapp, for your consideration of the Health System Protection Act. I had some written remarks here, but I want to just say first that to my colleagues, I appreciate your feedback and your thoughtful consideration of the legislation. To Representative Bonner, again, thank you for your collaboration on this. And again, the recognition that I don't think this legislation is finished. There's still a lot of conversations to be had, and certainly taking into account some of the things that we have heard today in committee, because this is where the work is done, and this is where we help refine the legislation. So I appreciate that. I do want to first acknowledge, like my colleague Rep. Boyd did, what happened in Delaware County, and which was has been the precipitous for this legislation, or the concept of this legislation. It has been around for a while, and I will give credit to my colleague, Senator Carney, Tim Carney in Delaware County, for kind of starting and getting this ball rolling. And I'm not 100% sure, but probably the legislation has been around for about 4 years. And a lot of that is because of what we saw happening at Crozier Chester Medical Center and the health system, a hospital system that was purchased by Prospect Medical Holdings in 2016, a private equity firm from California who came into our Commonwealth and decided that endangering the lives of nearly 500,000 children and adults in our county was a good way to generate personal wealth for a handful of executives and shareholders. We watched, and I've only been particularly watching for 3 years, but I know there are colleagues of mine who've been watching for much longer. We watched as that system was taken apart. We watched as 4 hospitals closed in succession. We watched as thousands of people lost access to their primary care physicians, to maternal child health services, to their community hospitals where they could go in the case of an emergency. we can't watch it happen anymore. And I know that it is happening across our Commonwealth. I've talked to many of my colleagues where they have seen this happen. We need to fix it. And again, and I agree with Representative Boyd, and I thank you for your comments. This is not perfect legislation. Believe me, if we could do more, I think that we would. But there are many, and we've met with, I don't even know, Erica, how many stakeholders, and Mr. Siggett, how many stakeholders we have met with on this legislation. And every single one agrees that, yes, this is bad. What is happening with private equity and for-profit in the state of Pennsylvania is bad. But getting everybody on the same page as to how we address it is really hard. It is really, really hard. So what we have is legislation, and again, you know, we've been working collaboratively with many people. I'm so happy to have my colleagues on the other side of the aisle working with us on this. We will continue to work on it. This legislation, it does not ban private equity in healthcare, but what it does is give the power to our Attorney General, our duly elected Attorney General, and the people that work for him to evaluate these transactions when they come into our state, when they come in and they don't have the best of intentions. We want to keep the bad actors out. And I've heard from the stakeholders who say, we need private equity. I have heard that. It helps our dental practices. It helps, there's, you know, concern around nursing homes. You know, we understand that there are instances where this is needed, but we need to make sure that the bad actors are not coming in and doing what we saw happen in Delaware County and happen in other parts of our Commonwealth happen anymore. So again, I thank everyone for their comments. I believe this is a pivotal moment for us as lawmakers elected by the people to represent their interests, and how we choose to respond to the crisis of private equity and for-profit and what they're doing to our healthcare system across the Commonwealth will speak volumes to Pennsylvanians about our courage to do what is right. So with that, I will, again, I just really want to thank Erica Fricke. I really want to thank Mike Siggett. Again, thank you, Chair Frankel and Chair Rapp, for allowing this legislation to be considered and move forward. And thank you to all of those who have contributed to what we have right now and will be contributing in the future. And I would ask my colleagues for an affirmative vote so that we can start to move something forward. Thank you.
Thank you, Representative Borowski, and thank you for your hard work on this piece of legislation. Chair Rapp, your comments?
Thank you, Mr. Chairman. First, Mr. Chairman, I didn't make any comments on the amendment, but I do want to thank you, Representative Borowski, and your staff and the administration who reached out to me to support the bill. And my vote today is because of the Bonner Amendment, which I assured the administration if we could get the Bonner Amendment on the bill, I would support the bill today. So I want to thank you and your staff for working with Mike Siggett and Representative Bonner and all of us working together to get the amendment on the bill today. I think that was critical. So from my remarks, healthcare facility transactions have taken on a prominent role in this Commonwealth, as we all know, over the last several years. The events that occurred with Crozier Health and Sharon Regional Medical Center have reignited the debate concerning what the role of the Commonwealth should have in overseeing certain transactions with not only hospitals, but with other healthcare entities. I did not support last session's bill as I felt it was too broad in scope and it left too much discretion to the Attorney General in determining whether to intervene in such transactions. I still have many concerns about this bill, as we've heard from others, to name a few, I am concerned whether the material amount to trigger oversight, even with the increase that occurred in committee today, is too low, thus triggering oversight of some transactions involving smaller healthcare entities that do not have the time nor the resources to oppose the Attorney General's oversight of their proposed transaction. I'm still debating whether nonprofit hospitals and health systems should be included in this bill. If we are truly concerned about these transactions, I question whether we should be providing oversight to all three groups: private equity, for-profit, and not-for-profit. In that vein, the General Assembly will need to determine whether this bill should focus on hospitals and health systems or continue to include other types of health care facilities, such as nursing homes and ambulatory surgical facilities. While transactions involving those facilities can certainly cause disruption in the healthcare space, I'm concerned whether including them is too much at this time and whether this bill instead should focus on hospitals to start. I would like to see more discussion on the cost structure laid out in this bill. Last session, there was an agreement to cap the cost that healthcare entities would pay the Attorney General at 50% of reasonable expenses. In essence, each side would pay half. The current language in this bill requires that entities of closing, unless whom are in dire financial straits and at risk of closing, unless the transaction is approved, to pay 100% of the Attorney General's cost. These costs are on top of the cost that the healthcare entities will have in paying attorneys and other experts to navigate this new legislation. In addition, while I do not support needlessly spending taxpayer dollars normally when there are oversight responsibilities by a state entity, each state entity pays its own cost, as that is the responsibility of the Commonwealth to provide oversight to the business community. I think it's fair to say that we all know this vote in committee today is merely the first step. There will likely be more changes to this bill as discussions progress, including in the Senate. However, what is occurring today in committee is a good faith attempt to address some of the concerns that we have with the bill. With the committee amendment that was just approved, I will be supporting moving this bill out of committee today. However, I am deferring judgment on this bill for the floor until I see what further amendments, if any, are approved. I believe we have a long way to go before we have a bill that could receive a substantial bipartisan support. But today's actions are an important first step in this process. So thank you again, Mr. Chairman.
Thank you, Chair Rapp. This legislation targets financial practices used within the healthcare sector that extract profit from healthcare facilities that can end up undermining patient care and access. By providing oversight mechanisms, Pennsylvania can ensure that healthcare companies don't end up compromising patient care in the interests of protecting investors. Today, Pennsylvanians have Crozier and Sharon Regional in mind when they think about private equity investment. But it wasn't long ago that we were talking about Hahnemann Hospital. And this isn't just taking place in the hospital space, although those closures may be more visible. I'd like to remind members of HCR Manor Care, which also filed for bankruptcy after an expensive sale-leaseback agreement. That facility faced documented issues in patient care, including violations that rose almost 30% in the year before the bankruptcy filing. In Pottsville, families spoke about being left on bedpans or not taken to the bathroom at all, in addition to serious falls that resulted in a hemorrhage. This bill does not ban private equity or even sale-leaseback agreements. In fact, the Attorney General can work with facilities to use these financial strategies while ensuring patient care isn't harmed. I want to thank Representative Bonner for his thoughtful engagement on this question and both his and Representative Borowski's continuing commitment to work through these difficult questions. This is an important piece of legislation, and it will take listening to stakeholders and while holding vulnerable patients in mind to craft something that can accomplish our goals. I'd ask our members on both sides to please vote yes. With that, I'd like House Bill 1460 as amended, a roll call vote, please, Devin.
Chair Frankel,
Yes.
Representative Benham,
Designation yes.
Borowski, Boyd, Hanbidge,
Designation yes.
Howard,
Designation yes.
Khan,
Yes.
Kozarowski, Krajewski, Mays,
Designation yes.
Berlaten,
Designation yes.
Sanchez, Schusterman,
Designation yes.
Venkat,
Yes.
Chair Rapp,
Yes.
Representative Bonner, Borowitz,
No.
Brown,
Designation no.
Day,
Yes.
Rupa, Roy,
No.
Rossi, Stare, Wordzik,
Yes.
Walsh,
Designation no.
Zimmerman, the yeas are 20, the nays are 6. The bill
Thank you,
passes out of committee.
Devin. House Bill 1460 will be reported as amended. Thank you, members. And then seeing that there is no further business, this House Health Committee voting meeting is adjourned. We will reconvene on Tuesday, June 10th. Thank you very much.